All right, hello and welcome to today's lecture. My name is Meredith Cutrer, and I'm one of the conveners here at the Early Medieval Britain and Ireland Network at the University of Oxford, and I'm the organizer of our network's academic lecture series. We are a multidisciplinary scholarly community comprised of faculty, staff, and students from across the University of Oxford, with an interest in the cultures, languages, and peoples of early medieval Britain and Ireland. Our lecture series provides a forum for leading scholars to present their latest research. We're very pleased to have with us today Dr. Charlene Eska, Professor of Linguistics in the Department of English at Virginia Tech. She has postgraduate degrees in Celtic from both Oxford and Harvard universities. She has published 3 book-length editions of early Irish legal text, and she has published on a wide range of subjects, including philology, early Irish law and literature, Welsh law, paleography, and epigraphy. She is currently working on her 4th book, which is an edition of Dovtak Mac Airshik's 17th century Irish legal glossary. Professor Eska, you're very welcome.
Thank you so much, Meredith, for your kind introduction. I'm honored and excited to have been asked to deliver a paper as part of the Early Medieval Britain and Ireland's Network Lecture Series. It's wonderful to be back in Oxford, particularly at this time of year with all the wisteria going. So at this time, I should like to acknowledge with gratitude, thank you to our IT support, and also thank you to the John Simon Guggenheim Memorial Foundation, the Department of English at Virginia Tech, and the College of Liberal Arts and Human Sciences, also at Virginia Tech, for funding part of the research for today's talk. So, yes, okay. Today's talk takes as its starting point the legal procedure for reclaiming lost and stolen property as given in the commentaries which accompany the recently found fragmentary early Irish legal text, Aidbred Claiming. I'll be using the process described therein as a case study to test methodological arguments surrounding legal similarities being a result of inheritance or not at the Common Celtic and or Indo-European levels. I'll be doing this by placing the legal process as found in Aidbred within the wider Western European context and working eastwards from the Welsh and Germanic law codes through to the Hittite and Babylonian laws of Hammurabi before ending up in 3rd century BCE China. Just a roadmap. So as a critical edition and translation of Aidbred was only published in July of 2022, I'm going to start by introducing the text itself, as no one really knew about the context of this legal text until recently. And then I shall proceed to discuss other legal systems for comparative purposes. First, however, we shall begin with some methodological issues. Robin Chapman-Stacey, in her 2015 Farrer lecture, summarizes the state of the field when she marks that, quote, historical linguistics, unquote, was the foundation on which Celtic studies itself as a discipline was largely constructed. Just as linguists seek to reconstruct elements of Proto-Celtic from attested forms in the modern and historical Celtic languages, so too might historians hope to recover something of the institutions, legal practices, and patterns of social life of the ancient Celtic peoples from practices visible in the medieval Irish and Welsh texts. Now, while this approach has brought scholarly attention to some practices which appear to be cognate, this approach can only get you so far, but it also explains historically, in terms of scholarship, why the Irish and Welsh legal texts have for so long been compared. So let me give you some examples. Right. D.A. Binchy, in his important contribution, Celtic Suretyship, a fossilized Indo-European institution, compared the medieval Irish and Welsh terms for type of surety, in other words, the mac in Irish and the mach in Welsh. Their term became obsolete very early and only survives in a few archaic legal formulas. Both go back to Common Celtic machos. The Irish term was early replaced by nodv, in large because mach sounds like the Irish word for son, boy, child, which is mach, right? Binchy then compares the suretyship system as found in the texts, compares what to be found in, for example, early Germanic laws, and suggests that the Irish law of suretyship may well reflect the various stages in the development of this institution throughout the Indo-European world. Indeed, the Irish and Welsh legal terms are linguistic cognates, but even Binchy himself recognized the different legal functions associated with the Irish nodv and the Welsh mach. There isn't really much that we can go on for the Irish word mach as it falls out so early. We also see a similar approach taken by Calvert Watkins in his article Sick Maintenance in Indo-European, where he compares the evidence from Hittite and Irish law surrounding the legal process for providing medical treatment and compensation for someone who's been injured. In both systems, the one responsible for the injury is the one who is legally responsible for providing the injured party's sick maintenance, in other words, like paying for their physician's fees and such. Even though both systems are separated by time and geography, he builds his case around the similar features of both systems, as you can see here on the slide. He further supports his argument for these systems reflecting a genuine Indo-European legal institution by proposing a shared reconstructed etymology for the Hittite term for sick maintenance, saktiatsi, and the Irish word socht, stupor. And he comes up with Proto-Indo-European soctus over here. So the approach taken here is further supported by the fact that sick maintenance is a fairly isolated procedure, only really being attested on the far geographical fringes of the spread of the Indo-European languages. And it helps when one can find cognate terms, as is the case with the Hittite and Old Irish terms. And all this, though, can become rather more problematic when one doesn't have attested cognate terms. If you don't have verbal similarities, right, it gets a little bit harder, right? What do you have? Indeed, the comparative method can yield fruits, but similarities can also arise from borrowing and from the simple basic fact that human behavior hasn't changed that much in the last some thousand of years. People are still exchanging goods and services, entering into personal relationships, ending personal relationships, stealing, causing injury, etc., etc., etc. So one does need to leave open the possibility that similarities can arise in that people have come up with common solutions to tackle common problems. Right. So before I tell you too much about Aidbred, I'll tell you a little bit about the early Irish legal texts and manuscripts, as it's possible that many folks in the audience might not be familiar with what we have and how things work. The earliest extant Irish laws might date linguistically, maybe, to about circa 650 CE, with most texts being redacted within a fairly narrow range of about 650 to 800, with the Lynchs Source, Great Tradition, that legal collection being dated most recently to latter years of the 7th century, although many of the legal texts are preserved in manuscripts of the 12th through the 16th century, so you have very old texts in later manuscripts. Aidbred, I'll just say, is not part of the Lynchs Source legal collection. Now, the true extent of the early Irish legal corpus is not entirely known, but scholars estimate that it is probably about 3 times the size of the extant early English legal corpus, so it's quite large. The semi-diplomatic edition of the medieval Irish laws, the Corpus Juris Hibernici, runs to over 2,300 single-spaced pages with no translations or discussions, and focuses primarily on texts preserved on vellum. And many of those texts still lack modern editions and translations. The field is largely given primacy to texts found in vellum manuscripts, sometimes ignoring a large body of unedited and unexplored material written on paper, because there had been a trend very, very long time ago on the field where some folks were of the view that nothing significantly old could be found in paper manuscripts, and old equals important, but we now know that that's not the case. Many of the early legal texts are accompanied by copious interlinear glosses and legal commentary, much like the format found in some medieval continental legal manuscripts. The normal pattern of scribal activity in Ireland was to copy the canonical text from manuscript to manuscript, with not change the actual text, while copying existing glosses and commentary, and simultaneously adding more contemporary glosses and commentary to the page. The results are legally and linguistically layered texts, such as sometimes in later manuscripts in the 16th century. Scholars can sometimes find close to 900 years of linguistic change on a single page. In terms of how the legal system itself worked, it was a compensatory system. Every crime had an amount of compensation associated with it, mostly, and the amount of compensation could vary depending on a wide range of factors associated with each case. There's no really case law preserved, so we largely have customary law and some promulgated laws. So when we talk about law in medieval Ireland, it's really easy to forget that the vernacular, like the secular laws, the so-called Brehon laws, were not the only legal system operating in the country. Aside from canon law, there were different customs and regulations in the areas with a large Norse presence. After the Norman invasion of Ireland in 1169, we see the introduction of English common law in the Norman-controlled areas, with Gaelic law still in operation outside these areas. In border areas, much like we see at the medieval March in Wales, get a mix of the two systems operating. Gaelic laws eventually get farther pushed to the fringes, and finally, under King James I in 1603, The so-called Brehon laws were deemed to have no authority in Ireland, as King James I, not he was the first one, proclaims that the Irish people were under the king's protection. Right, so having dispensed with a bit of background, returning to Aidbred, I found the text while working on another text on Google, Wrong Judgment, which you can see here. And during the course of editing this, it became apparent that a new text had begun about 2/3 of the way through what we thought was only on Google. So following the end of section 58, the main manuscript here, which is Trinity College Dublin manuscript 1387, there's this large decorated initial over here, okay? And it's all the size and ornamentation only used in this manuscript for the start of new texts. The subject matter after this is consistently about the legal process for regaining lost and stolen property, whereas on Google covers a wide range of topics, everything from shipwreck to misbehaving people of all sorts and raids. So the title of a legal text known as Aidbred was given in John Lynch's 1662 Compilations of Maresia, so we've had the title for a while. In chapter 20, Lynch responds to charges made by Gerald of Wales that the Irish were a nation without laws. And to prove Gerald wrong, Lynch helpfully provides the names and descriptions of several Irish legal texts. And one of the titles he gives is Aidbred, and he tells us that it's a text about theft. So Lynch's legal text is here, and it contains the following text in the following order, and the spellings are what are given in Lynch. And he mentions other texts in passing, but this is the main list. Now, Lynch's source for these texts is the 17th century antiquarian Dubelchuk McGarrishay, who owned all of the main manuscripts other than Edgerton 88, where Aidbred is found. And he says, I saw a great number of thick volumes of Irish laws, with the text written in large characters and a large space between the lines, to admit more conveniently in smaller letters the glossary on the meaning of the words. The pages were covered over with copious commentaries inserted between the text, as are usually seen in compilations of canon and civil law. Some years ago, Duvall McFerbish transcribed from these books the titles I have given. Okay. Aidbred consists of 12 sections of excerpts from the canonical text itself, of which only the first 10 sections, maybe, can be fairly confidently stated to be complete sentences. Almost everything else are fragments accompanied by copious legal commentary. So the main manuscript, 1387, formerly known by the shelf mark H515, maybe dates to the 15th century. The scribe's name is Sean. He said he wrote for McGeegan, and that's all we know. The canonical text of Aidbred is Old Irish, but certainly after about 750. And the glosses and commentaries from all the manuscript witnesses, they range, probably all of them, range from the Old Irish to early modern Irish periods. And material from the canonical tract and the Middle Irish commentaries, particularly the commentaries, are the focus for today. Now, while there's been some significant criticism in the past of the value of the legal glosses and commentaries, it's now accepted that the glosses and commentaries are not necessarily examples of lawyers playing clever linguistic games in the style of Isidore Seville's Etymologiae, or building unrealistic legal systems in the commentaries, but rather they reflect, actual intellectual and legal concerns. For example, when Gillen and Eve McGavigan, in the late 13th century, set out to compile his legal treatise as a means for instructing young lawyers, he used not only the legal texts themselves, the canonical tracts, but also the commentaries. For example, he frequently paraphrases some of the commentaries from Section 5 in Aidbred in his treatise, and he also refers to material from Heptad 64 in the same order in which that material is presented in the text. This is as noticed by Fergus Kelly in his excellent edition and translation of Gillen and Eve's treatise. In addition to illustrating some of the texts that Gillen and Eve had access to, it also shows how much law presented in the commentaries represents at that point current 13th century legal principles in action. So, Aidbred begins by stating that someone of high noble status can claim their property immediately upon seeing it, provided that he swears an oath that the property being sued for does not leave him as part of what he would give to a client as a fee, or as a private or commercial loan, or as a deposit, or as part of another type of agreement. These are all common situations where one's property could legally, legitimately end up in someone else's possession. The standard procedure is that each person who claims their property from someone of lower social rank needs to have at least one compurgator who will support their oath. Now, it should be noted that this is not the same, having compurgator, it's not the same as providing evidence that the property is his. Each person can swear up to the value of their honor price, which is based generally on gender and social rank. And the number of necessary compurgators depends on the status of the individuals involved. Furthermore, with regard to stolen livestock, the number of compurgators varies depending on the value of the livestock in question. So 4 compurgators are necessary for sheep, pig, goat, or things of lesser value. 7 are required for livestock ranging from a hen to a cow. The legally unworthy, don't like using the term, but legally unqualified plaintiff needs twice as many compurgators to prove his case against a worthy, like a qualified defendant. It should be borne in mind that certain classes of people, except in exceptional circumstances, were not legally able to act as compurgators. So, in other words, or give evidence or act as a plaintiff or defendant on their own behalf. Those considered legally unqualified to provide legal evidence include slaves, castaways, foreigners, the semi-free, senile, the mentally incapacitated, those without land, thieves, prostitutes, and clerics who have fallen from holy orders. The commentaries then give us a list of the 4 stages of the legal process, which precede the final legal claiming of the disputed property. Now, these stages do not apply in their entirety to the high noble because he takes his property, right, when he sees it. Right? So the commentaries describe each of the 4 stages as follows. The preliminary oath is the oath that he swears that the property did not part from him in sale, contract, etc. The next stage is seizing, which is defined as stretching out his hand onto the head of his cattle, right? In other words, laying his hands on his property. Third step, possession, which refers to the process of putting the disputed property into the custody of a neutral third party for safeguarding until the legal judgment, the final stage here is given. Like the final stage is the legal judgment given by the judge hearing the case. The commentaries make a point of stating that the stages of the process must be followed in their correct order. If the plaintiff were to seize the property before giving the preliminary oath, the plaintiff would be assessed half the fine of theft as if he had stolen the property. Okay, so in terms of all this works, let's have a scenario. Let's give a little example here. Let's say that John's beloved cow, Maisie, has gone missing. Once John notices that she is gone, he notifies everyone in the local community that Maisie's vanished and he's looking for her. It's possible that Maisie was stolen or had wandered off. Maybe John hadn't kept his fences in good repair, or perhaps something frightened her and she ran. John really wants Maisie back and does the responsible thing, which is to go to the 7 standard locations in the neighboring communities where people tend to gather and exchange news. The mill, the blacksmiths, the lord's residence, etc. Along the way, he sees Maisie, or at least he thinks it's Maisie. So he locates the owner of the grazing enclosure where he found her, formally makes a claim that one of the cows is his, and makes a preliminary oath, hopefully in front of witnesses. The owner of the grazing enclosure denies John's claim, and in fact, John is not entirely certain that the cow he saw is Maisie. Either way, John puts his hand on the cow's head and claims her as his, just in case, right? At this point, the cow is then taken into the custody of a neutral third party in John's territory. John thinks that Maisie's been stolen, that the presumed thief, right, has to travel to John's territory for the legal proceedings, and the cow must be impounded there. Meanwhile, John continues to wonder whether he's really claimed the correct cow or has he made a mistake. Now, he's given time, right? He's given time to find a former milker who's left John's employ after Maisie went missing and now works maybe a few territories away. So that he showed, because he needs time to go get her, say, hey, can you come and verify the cow's identity? When she arrives, she's convinced that the cow in question is Maisie, and Maisie recognizes her as cows will recognize those who regularly milk them. Yay, all is well. Yet the milker is of lower social rank than John. Both John and the defendant are of the same social rank and considered to be legally capable members of their community. Now, because of all this, it could take, if I've done the math correctly, a total of maybe 14 compurgators, to swear oaths in front of a judge that the cow in question is Maisie and belongs to John. Now, women are normally only allowed to give evidence in a limited number of circumstances, usually those situations involving other women, things involving like legal entry for women, sexual matters, etc. That being said, it'd be really unusual for the female milker's evidence to be discounted in a case such as this, especially if the female milker's evidence is crucial for the stolen livestock to be returned to the rightful owner. And there's evidence to suggest, this is something that Fergus Kelly has talked about, that the professional milker could be male or female, right? So number of complicators here is depending. So it's uncertain whether the legal commentaries here envisioned only male milkers, female, a mix of both, or what. Now, the defendant can deny all of this, totally deny all of this. And he can do it with only 7 complicators. But those complicators, we need to swear that the defendant had the cow all along, that he legitimately, he thought, bought it from someone else. If it turns out that the defendant had thought he legitimately bought Maisie from someone legally able to sell her, the judge is going to decide in John's favor, and John gets Maisie back. That then leaves the defendant to pursue the thief who sold him the stolen cow, because he's out money at this point. And he needs to try to get his money back from the thief and bring him to justice. Now, the thief would not only assuming he can find the thief, right? The thief would not only have to pay back the defendant the price paid for Maisie, but also pay fines to John for stealing Maisie in the first place and to the defendant for selling him stolen goods. So this gets really expensive really quickly for your thief. If the receiver of stolen goods knew, however, that he was buying from a thief and or that the goods were stolen, he himself would have a degree of legal liability and also owe the owner of the stolen goods compensation. So it's a bit of a daisy chain of liability. Now, it should be noted that the commentary from a different source brings up the possibility that the person claiming stolen property does not necessarily need to be the owner of the stolen property. The claimant might recognize the property as being stolen, like, hey, that's torn cow's Maisie, right? And thus start the legal process of suing for it. According to that commentary, the plaintiff in this situation is allowed to take the stolen property from the defendant and guard it until the rightful owner is found to take the property away. It should also be noted that anyone who finds lost property and doesn't know who the owner is and takes it into their possession for safekeeping is obligated to announce the find. So for the finder, because there's like a finder fee in all of this too, right? It's not necessarily finders keepers, but it can be. For the finder to receive a full share of what was found on land, he needs to make a proclamation that he's found the livestock or lost item, because, right, it applies to both, at the 7 locations, right, in the territory. And he needs to do this throughout the 4 nearest territories. So not just in his local place, he's got to go around. And these locations are where people tend to gather and would regularly and frequent, such as the mill, places where you exchange news. Now, he finds something like on the sea. He needs to proclaim the find in the same 7 places or whichever places for seaside communities are designated as the equivalent. He needs to do this throughout the 3 nearest territories. The sea is considered the 4th, and that refers to proclaiming it there are any like sailors nearby, right? Now, if the property remains unused in his possession for 10 days after doing so, he has the full share of it. If he does not proclaim the find and it does not remain unused in his possession for 10 days, he owes the full fine of theft. The finder's share in the value of the found item and or his liability to the owner, it really varies depending on when the finder makes a proclamation, early or late as it were, and whether he used the found item or livestock before the 10 days had passed. On a side note, in terms of like how far we have to make these proclamations, in medieval England, the finder of a dead body apparently was obligated to notify the 4 neighbors closest to the find. And once ordeals were abolished, juries would commonly draw from 4 neighboring townships. And although not directly related to medieval Ireland, it's interesting to note that in early medieval Brittany, the geographical range that non-aristocratic lay people traveled to conduct public business, so acting as a witness, surety, or compagator, was within or between neighboring communities, normally not more than 3 or 4 village communities away from their own community. So there's seems to be something commonality in terms of in terms of common geographical interactions here. A similar concept to the 4 neighboring territories appears in the Irish laws of neighborhood, where each farmer gives a floor pledge to the 4 neighbors on each of the 4 sides of the property. Okay, now that we have established what the procedure is for getting lost and stolen property back and the various ways in which the receiver of stolen goods figured into all of this, let's take a look at how medieval Welsh law handles the same situation. The medieval Welsh laws are traditionally attributed to Hywel, a 10th century king, but are attested in later manuscript versions starting in the mid-13th century. And there are both medieval Welsh and Latin versions of these laws. Like the early Irish laws, the Welsh laws describe the procedure for claiming one's lost or stolen property, beginning with identifying the property as one's own and the proper swearing of oaths in front of witnesses by both the plaintiff and defendant before, though that's really necessary for either to have a legal claim on the disputed property. We find similar provisions where the laws not only describe the procedure for claiming one's stolen property when it's been found in someone else's possession, but the laws also distinguish between property which has been given into another's possession as a loan, whether for private or commercial use, deposit, gift, or as part of some other agreement. In the Your Worth texts, the oath that the plaintiff needs to swear regarding his property found in another's possession is strikingly similar to what we find in the Irish laws. And so let the claimant swear that there was no owner of it who had power either to sell it or buy it save himself. And in addition to that it did not leave him either by gift or by loan or on deposit, nor was it sold or given, but taken from him by theft or surreption or lost. And let him name the day or night of the week when it was lost, and name the week of the month, and name the month of the season, and name the season of the year. So procedure in Welsh law is similar to, again, what we find in Irish law. The claimant seizes livestock in someone else's possession, claims his property, and, if no one objects, takes the property with him, and then takes it to a judge who confirms his right to it. There's an objection to the claimant's right to the property. He and the defendant establish their respective claims to the disputed property. The claimant makes a plea that the property left him by theft or some other loss. In other words, the property had no right to be in the defendant's possession. The defendant then, this is much truncated, and there are bits of this. For those of you who are familiar with Welsh law, you know that I've just snipped bits. The defendant then enters his plea while having one hand on the disputed livestock and the other on a relic. The prescribed pleas the defendant can make are birth and rearing. In other words, he claims the disputed livestock has been his since it was born. He also owns the mother, right? So the mother's livestock is in his possession. Keeping without losing, where he swears that he had it at least a week or a month before it was lost, and voucher to warranty. The defendant has a warrantor who vouches that he sold him the property. Now, these are really, really similar to pleas found in the Irish material, where one can enter a plea of growth, which is the same as, it was born, you owned it, or a purchase with or without prior right. On the third plea, the defendant enters purchase without prior right. The defendant says he bought the disputed property at a point of time, although it was after the plaintiff says that his own property had gone missing. Regarding the receiver of stolen goods, the Welsh laws also have the provision that the owner of the stolen goods has the right to track his property as far as he can, despite how many times his property might have changed hands since the time it was stolen. And the owner has the right to trace his property as far as he's able. Furthermore, the receiver of stolen goods is liable to pay fines no matter how many times the property has changed hands up to the 100th hand. So a very similar system for dealing with the same problem. But that doesn't necessarily prove common inheritance or even borrowing. This is not to discount what is in common, as there is quite a lot in terms of the procedure here. But there are other ways we can approach these texts, especially as many of the earlier studies on the laws didn't always look at their contemporary contexts. While it might be tempting to think that the similarities between the two systems are a result of common inheritance, it would be useful to look at that theory in light of the early English material, as we know that there was contact and borrowing between the Welsh and English laws. So turning to the early English laws, these laws here, which may be date to about 686, Section 5 states that if a person steals property from another person, and the owner afterwards takes possession of it, let him, the accused, vouch in the king's hall, if he is able, and bring him who sold it to him. Now, if he can't produce the seller of the stolen goods, he has to return the property to the rightful owner. Section 11 of the same text deals with the receiver of stolen goods being reimbursed then by the seller. And as a side note, for those who might not do medieval legal things, the earliest written vernacular English laws tend to date to maybe only about 50 years or so earlier before the earliest Irish vernacular laws. So we're roughly in the same time period. The 10th century laws of Alfred, Section 42 of the prologue concerns announcing any stray cattle which might come into one's possession. Section 25 concerns the merchant who did not buy his goods in front of witnesses and thus is accidentally selling stolen goods. He must take an oath that he is neither the thief nor an accessory, or he must pay a fine. And something that's going to come up over and over again as we look at different legal systems is that purchasing goods in front of witnesses is necessary, right? It's truly necessary. You're in deep trouble otherwise. Now, even though there has been some borrowing between the early English and Welsh laws, for example, in Laws of Alfred, section 43, there's a Godborg, which seems to be a borrowing the Welsh concept of the Byddu, right, the suretyship of God, and the Welsh word for the heir apparent, who figures so heavily in the Welsh laws of court, the Edling, is a borrowing from Anglo-Saxon Atheling. And we do see degrees of cross-border cooperation in the 10th century agreement of Dunsada for tracking livestock. But I don't know if we can, no case can be made for borrowing between the two systems in this instance. Okay, next, we're going to turn our attention to the Visigothic laws. While this may seem like a strange choice at first, it should be borne in mind that from at least the latter part of the 7th century, some of the works of Isidore Seville, such as his Etymologiae, were known in Ireland. Whether the works arrived directly from Spain or from a different trade route is a matter of debate for some scholars, but what's not in doubt is the heavy influence of the Etymologiae on the style of etymological glossing found so frequently in the legal texts. It should be noted that the etymological glosses primarily almost all belong to some of the earlier stages of legal glossing and not the later ones. The Visigothic laws were composed in Latin. Like I said, the previous law codes I mentioned were all composed in respective vernaculars, aside from some of the Latin Welsh laws. And they're a mix of customary laws and aspects of Roman law, although it should be noted that the laws are noteworthy for eliminating the distinction between different legal practices for Goths and Romans. And instead, everyone was sort of subject to the same legal system, at least on paper and theory. Although parts of Britain were once parts of the Roman Empire, there was no lasting impact of Roman law on the vernacular laws themselves, at least not like we get for the Germanic stuff. And Ireland was never part of the Roman Empire. So in case anyone was wondering what Roman law has to say about theft and receiving stolen goods, there are two types of civil remedy. The first was recovery of the stolen property, and the second was obtaining damages. These remedies are not mutually exclusive, just as they are not mutually exclusive in Irish law. The thief still has to return the stolen property and pay a fine. See Digest Books 13 and 14.2 for the details. This is not to suggest in any way, I'm not suggesting in any way that the Visigothic law material comes directly from the Digest. No, I'm not saying that, no. Not at all. So the Visigothic laws were basically the Irvingian Code of 681, which itself is a revision of laws established in 654. And they themselves are a mix of earlier and later laws, the early ones being labeled as antiqui and the surviving copies. What is clear from all this is that the earlier laws were still considered relevant and therefore included. So in Book 7, Title 2, Section 8, which has the heading, "Where anyone ignorantly buys stolen property of a thief," we find the following. "It shall not be lawful for a freeman to buy any property from a person unknown to him, unless he can produce a reliable person as a witness, and thereby be able to allege the excuse of ignorance. If he should do otherwise, he shall be compelled by the judge to produce, within a reasonable time, the person of whom he bought said property, and if he cannot find him, he must prove his innocence, either by oath or by witnesses, and show he did not know that the vendor was a thief, and he must restore the property which he purchased to the owner, after having received from the latter an amount equal to half the price paid for said property. And both shall promise under oath that they shall make diligent search for the thief. If, however, the latter cannot be found, the purchaser shall only be compelled to restore to the owner the property which he bought." Now, this section of the laws is remarkably similar to what you find in the Irish legal commentaries. Though that mentioned earlier, the Irish commentaries do have a provision where the owner and the innocent receiver of stolen goods can actually band together to go find the thief so that each of them can get, fully compensated if they are able. Further interest, Book 8, Title 5, Section 6, that has the heading, "Public notice shall be given of strays by him who finds them," as follows. "It shall be lawful to take up horses or any other animals that have strayed, but he who does so must immediately give notice of the fact to the bishop, the governor, the judge, and other authorities of the district, or to a public assembly of the neighbors. If said party shall not give notice, he shall incur the penalty of theft. The same shall apply to other property taken up under the circumstances. And again, here we have the similarity with the Irish material, where proclamation of the found property must be made in order for the finder to avoid fines of theft. The next section in the Visigothic laws states that the finder of wandering animals must take proper care of them. When the owner finds the property, he should give the finder a fee for tending the animals. What we don't find, however, is a process by which the owner actually proves his legal right to the property. And it should be noted that these provisions in the Visigothic laws do not appear to derive from Roman law. It looks like customary law instead. What's really interesting is what happens to some of these customary laws, is what happens to this material around the year 1000. So the Visigothic laws, the Liber Judiciorum, is formed the basis for the Liber Judicum Popularis, compiled in Barcelona around the year 1000 by one Bonham, who was a legal expert and judge. This compilation includes the full text of the Liber Judiciorum and was designed both for practicing lawyers and for legal training. And the only complete surviving copy also contains a detailed legal glossary at the very end of it in the manuscript. As discussed by Esters, it was similar to the collection of Lombard laws, the Liber Papiensis, also compiled around the year 1000, which contains both the Leges Languedorum and Carolingian Capitularies. In other words, it also contains earlier and later laws. In the significance of both legal compilations in regards to my talk today, is that the manuscripts of these legal compilations have the same layout, basically, as some of the Irish legal manuscripts. So Winnie Davis has noted the similarities between the manuscript layout of the Liber Judiciorum Popularis and the Irish legal manuscripts in her Chadwick lecture, and Ester kind of puts together the similarities between the Visigothic and Lombard stuff. So basically, and with all of these, you have the same mix of earlier and later legal thinking, and it's clear in each of these cases that the older material was still considered relevant in that the canonical text was surrounded by interlinear glosses and marginal commentary. So in terms of what this looks like, here is manuscript page we've already seen again. This manuscript dates from like 1570s. This was Irish. This is the Lombard, Liber Papiensis looks like. And this here is what the Liber Judicum Popularis looks like here. All very similar. So while the contact between Catalonia and northern Italy is well known, as both were at one point under Carolingian rule, Esdras notes that there's evidence that Frankish legislation, quote, might have played a role in Catalonia around 1000, although this is not reflected in the Liber Judicum Popularis, end quote. He further notes that the legal vision that becomes apparent in the law books from Barcelona and Pavia points to a new appreciation of old law around 1000. In the Italian case, the Lombard laws and later legislation relating to them, and in Catalonia, the Visigothic laws, were regarded as canonical in their wording. So the manuscript layout, leaving ample room for annotations and commentaries, would suggest that both law books sought to address lay judges and legal experts, albeit in different ways. The Liber Papiensis, the space on the margins was soon used for juristic comments and explanation, whereas most of the marginal and interlinear glosses in the Liber Judicum Popularis are best explained as destined for more elementary legal training and practice. All right, well, we've been talking a lot about the Lombards. What do the Lombard laws have to say about stolen property and the receiver of stolen goods? Section 232 of Rother's Edict, right? Again, here, I'm not going to read all this out. We see the importance of knowing the seller and the purchaser having to take an oath that he did not knowingly purchase stolen goods. This dates about 643. Laws of Liutprand, somewhere between like 713 and 735. We find more or less the same law for buying a horse with the same emphasis on witnesses who can vouch for the purchaser in the event that the horse was stolen from somebody else. So laws of Salian Franks, like Salica, think Clovis, early 6th century with later 6th century additions. Basically, in this section, right, concerning the owner of an animal who tracks it for 3 days and finds it in someone else's possession. If the owner declares they bought the animal, if the other person declares they bought the animal, a third party is brought in to solve the dispute. If the owner finds it after 3 days, he can't get it back if the other person says he purchased it. If the owner takes the property without going through a third party, he himself is liable for a fine. So something we've seen similarly. This is similar to what we see in the Irish commentaries, where the owner is liable for a fine if he takes his property back too soon when there is dispute over ownership. For those of you who might have been wondering, thinking I'm awfully far away from Ireland and wondering what, if anything, Icelandic law has to say on these matters, there's a lot. Icelandic law has a lot to say about these matters. In sections like K to 5 in Gragas, right? The laws are maybe written about 1117. Like I said, lengthy discussion of ownership marks and wandering livestock. Takeaway from all of this is that if you find any stray livestock, you should take it in and care for it. You can use it, but you must have told the neighbors, right? You need to tell the neighbors that you have the livestock. The owner doesn't count the livestock by midwinter. 5 neighbors agree on the value of the livestock, which the owner will pay if he eventually turns up, okay? And on and on and on. Right, so far, I've discussed legal systems of societies which have had varying degrees of contact with each other or not. But in our examination of these laws, right, it would be wise to look farther afield in case anyone is wondering, well, thinking back to Calvert Watkins, right, and thinking about, well, similarities due to Indo-European inheritance or something along those lines. So in the Hittite laws, which date to about 1650 to 1500 BCE, Section 66 and 71 are relevant, and that Section 66 allows the owner to take his livestock back if it has wandered into somebody else's corral. He could just snag it right back. 77 states the finder of lost livestock can use the livestock so long as it's been proclaimed to elders. Okay, again, here we have proclamation. If the finder doesn't do so, he's arrested as a thief. Okay, all of this sounding very familiar right now. With the Hittite legal material, one needs to be really mindful of borrowing from other Near Eastern legal systems. So many texts came through the scribal schools. So, Westbrook has talked a lot about this and has argued that there are so many of the common legal provisions in the codes reflect his point of view a wider Near Eastern cultural tradition. So, for example, the laws concerning when a pregnant woman has been struck, it's almost the exact same across like half a dozen of these, everything from the Codex Lipid Ishtar to Hammurabi to Hittite to the Middle Assyrian laws, etc. Okay, so let's look at laws of Hammurabi, circa 750 BCE, which are not linguistically related at all to anything else we have looked at today. Sections 9 through 11. This thing reads like something out of like American daytime TV show, where we have a legal procedure very similar to what we find with the Irish, where someone finds their property in someone else's possession. The possessor says he bought it legitimately and has witnesses to prove it. And the owner brings witnesses to support his claim to get his property returned. If the buyer names the seller and the owner produces witnesses to identify the property, judges then hear the case and determine whether the seller is in fact the thief. If so, the owner gets his property back and the buyer is reimbursed for the purchase by the thief. Then the thief is put to death. So, yeah, expensive. Complications, like serious complications, arise when the seller cannot name the buyer or the owner cannot produce witnesses. Yeah. This is not to suggest that there is necessarily any borrowing from the laws of Hammurabi into the Hittite laws here, but the legal provision is similar to what we have seen elsewhere. So far, all the legal systems we've examined, right, there has been the question of whether the commonalities amongst them are a result potentially of them being inherited common Celtic or contact or a fossilization of archaic Indo-European legal practice, which might obscure our path, to move forward, what belongs to which, if that is even a legitimate question to ask, right? But in other words, let's just sort of step back. What if we looked at a legal system that's not Indo-European or in contact with any other Indo-European cultures? In other words, what happens if we completely remove, right, the possibility of contact and potential inheritance? Right. So this brings me to the fragments of Chinese Qian laws, which were found in the grave of Si, who was a scribe, clerk, and later whose task was trying criminal suits. These date to the mid-3rd century BCE. These are written on bamboo strips. These fragments contain both administrative and penal law. They were discovered in 1975. The fragments in no way cover what we would consider to be like, a full range of a legal system, right? These are only bits of fragments. And I'll state that I'm relying entirely on the translation and the edition, so I have absolutely no working knowledge at all of the language of these texts. And I need to formally thank my colleague, Jiwoo Shia, for drawing this group of laws to my attention. Group D, sections 8 through 20, which obviously are not all on that slide, are really relevant. Okay, obviously, this is really different from what we've seen before. But what they're saying is that the receiver of stolen goods is only held liable if they knew the goods were stolen. If he did not know the goods were stolen, he's only punished based on the value of the stolen goods in his possession and not for whatever else the thief might have stolen. Anyone who knowingly partakes in the profits of the stolen goods were also held liable just as the thief. Now, while some of the details differ, at its core, there's the same legal principle that we have found in the other texts, i.e., liability of the receiver of stolen goods depends on whether he knows he's receiving stolen goods. What we have attested does not deal with the actual process for claiming the property back. It's just not there. We just don't have it. Okay, conclusions. Having spent the better part of the last hour examining laws related to stolen goods, wandering livestock, and the sometimes unwitting receiver of stolen goods, we're a long way in both time and space from where we started in medieval Ireland. And we've seen many similar laws and legal procedures. Can we make a case for inheritance at whatever level, contact, or simply people finding the same common sense solutions to similar problems? Do we have, in some cases, a combination of one or more of these factors at play? How much detail of the legal procedures and some of these laws just doesn't survive, just wasn't written down, and everybody on the ground kind of knew what they were doing, even though they didn't write it down, right? Will we ever be able to say with confidence one way or the other? Perhaps we are left with more questions than answers. What I've hoped to accomplish here today is to highlight that it is worthwhile to examine these laws, both on their own terms and within their respective cultural contexts, and to suggest that caution should be employed whenever we find similarities in legal systems where the languages are related to each other, however distantly, and where we know there's been significant cultural contact. Not everything that looks similar is due to inheritance. Not everything that looks similar can be attributed to contact. Thank you very much for your time and attention.